in my opinion, one of the issues, at least on the plaintiff's business side, right? So plaintiffs firms all over the country who are getting called by the same vendors, same third-party partners, things like that, is you've got a lot of companies that want to be great at everything. They want to take over the whole world, right? They want to do case management. They also want to do AI. They want to do whatever the other thing is, so that part of their pitch to you can be, hey, you can get rid of X, Y, and Z and just hire us. But as a result of that, you're going to sacrifice on the quality of all of it, is what I've found.
Welcome to Trial Lawyer View, the podcast dedicated to the fierce yet compassionate lawyers who fight every day for justice in the courtroom. Our guests are top trial lawyers and their firms who share their stories and experiences, offering valuable insights into their journey, as well as expert guests who provide actionable strategies and practical tips for personal injury lawyers looking to optimize their operations, enhance client service, and drive growth in their practices. Trial Lawyer View is brought to you by Synergy. At Synergy, we aren't just a service provider. We are a strategic partner for personal injury law firms, seamlessly integrating with law firms to boost efficiency from day one. Outsourcing cumbersome administrative tasks like lien resolution and Medicare compliance to an expert partner like Synergy enables personal injury firms to focus on what they do best.
Nick Verderame is a trial lawyer who's built his career on fighting for justice in some of the toughest and most high-stakes cases. As a partner at Plattner Verderame, he represents clients in catastrophic injury, wrongful death, and product liability cases, with a reputation for relentless advocacy and results that speak for themselves. Before entering the practice of law, Nick sharpened his storytelling skills in journalism working at CBS News and ESPN, a foundation that now helps him craft compelling narratives in the courtroom and connect powerfully with juries. His thought leadership extends beyond trial work. He's published nationally on issues like sports-related concussions, helping shape conversations around accountability and safety. But Nick's impact stretches far beyond individual cases. He serves on the boards of the AAJ and the Arizona AAJ, where he is a tireless advocate for preserving and strengthening the civil justice system. Sought after speaker and community leader, Nick is also deeply invested in mentoring young lawyers and building a stronger, more connected legal community in Arizona. Whether it's championing clients, influencing policy, or coaching youth sports, Nick brings passion, leadership, and a drive to make a difference. In today's episode, we touch on his background in sports broadcasting, his evidence and trial strategies, law firm operations, technology, and more. Nick, welcome to Trial Lawyer View, and thank you for being with me today on the podcast.
Thank you, Jason. Happy to do it.
I want to ask you about your sports background, but before I do that, you've been, my understanding from a little bit of research, that you've been to 26 Major League Baseball stadiums. How cool is that?
It's awesome. It's one of my favorite things to do. It started organically, actually through trial lawyer stuff. So my dad's been a trial lawyer forever, been going to conventions, and back in the day when you actually had to travel for depositions and stuff like that. And so we would make family vacations out of it. And we would always, if we were going to San Francisco and the Giants weren't in town, he would push the trip a week if he could, or extend it a week to make sure we got baseball games. And it was one of those things where one day I woke up and had been to, 15, 18 stadiums, something like that, and kind of thought, I'm going to make a run at this. So now every year I try to get a couple new stadiums in. And it'll be tough to get to all 30 until the A's and the Rays actually find real homes, but it's fun to do.
I think one of the coolest experiences I had was in Old Yankee Stadium. I got to watch a game in George Steinbrenner's box, and I don't know if you've seen that the way it used to be set up, but they had just incredible Yankees memorabilia in that space, like the original contract, I think, with Babe Ruth, and like just some really cool, unique stuff. And it was really a very, very awesome experience to see a game like that.
So I was lucky enough to see a couple games in Old Yankee Stadium. And then also I've seen games in New Yankee Stadium because I used to live back in that neck of the woods. And my first game in New Yankee Stadium, there was like a 4-hour rain delay. And fortunately, my buddies and I hadn't gone into the stadium yet. So we just hung out in the area and waited for them to announce the game was starting. And around the fourth inning, the crowd was so small that because it was a Sunday afternoon game that was becoming a Sunday night game, that they just made it open seating. And in the New Yankee Stadium, they've got those huge leather seats right behind home plate. So my buddies and I sprinted down from all the way up in the third deck and got like fourth row seats directly behind home plate that were like recliners you would have in your living room.
That's awesome. Yeah, I've been to the new stadium too. Definitely very cool what they've done with it. Well, so your background is in broadcast journalism before law, and you were ESPN for a while. I'm curious if that training shaped the way you approach juries or communicate with clients. Like what were the things that you took away from that have helped you once you went to law school and got out in practice?
A ton, absolute ton. I started as an investigative journalist. And I mean, the first story that really got me into investigative journalism almost got me kicked out of high school. And so that kind of gave me the juice and the motivation that, hey, this stuff's kind of cool. So just that disposition of asking questions, digging deeper, going after whether it's a school administration, a big corporation, or an insurance company, digging and putting up that fight. But I think, sure, the way you formulate questions, the way you analytically and critically look at things, that all, from journalism school is helpful. But I think the biggest thing that I've taken away that I still use every day. 10 minutes ago, before we started this, I was preparing a client for a deposition and literally started the sentence with, I learned when I was in journalism school, is listening. That listening is a lot more difficult than people realize it is if you're doing it well. And so listening or learning how to be a good, active listener who is in that moment and actually listening and not thinking about something else. And then the other thing, ironically, coming from a TV background and now being a litigator, beyond learning how to communicate with people and stuff like that, is learning the importance of silence, whether it's after you make a point to let it sink in, or whether it's in the middle of a deposition and the person you're deposing, isn't giving you the whole truth. And as opposed to continually digging there, one of the tricks that I learned in journalism school was just sit silently. People hate silence. People will try to fill silence. People will just keep talking. That is something that I truly use on a weekly basis. And I think about Sue Copin, my journalism teacher, who taught me that.
So do you have a moment, like a gotcha moment, where that translated into an advantage in a case that comes to mind?
Yes, but it happened like 2 weeks ago and I'm still litigating it. So I don't want to talk about it.
I got you. Yeah.
Yes, I got a whole new angle on a case and evidence that I didn't know existed. But for a deponent just trying to fill silence because they were uncomfortable.
I had Brian Breiter on the podcast probably about a year ago, and he's an improv guy. And during that episode, there was a pretty lengthy discussion just about this idea that you just talked about, which is listening, really listening to what's going on, understanding what's going on in the courtroom, so that you're not in your head thinking about what you're going to say. It's listening and being able to talk more conversationally, and that also that pause, that ability to sit with silence, to all of those things were things that he talked about as critical in terms of learning how to be better in the courtroom.
Well, and it's so difficult in and out of the courtroom now. I mean, we're doing this on our computers, right? Everybody lives on Zoom. There are so many other things going on your computer in any given moment. that to really just be there with somebody and listen is very difficult to do in a deposition, right? Are you thinking about your next question? Are you looking at an outline thinking, if they say yes, I'm going this way. If they say no, I'm going this way. In trial, it's the same thing. And to me, a big part of it comes down to, it's a preparation thing, right? Because if you're truly prepared, you truly know the facts that you're there to talk about or the evidence that you're there to present the jury, and you know that case inside and out, then you don't feel the need to be tied to whatever paperwork it is that you've brought to make sure you don't miss something. And you can really just sit there and listen, make a decision on what they're saying. Is this an important thing to follow up on, or can I now go back to what I've already prepared? But that early preparation, I feel like, is key to being able to just feel like I'm in the moment, like I'm just talking to anybody. And that, by the way, is the best time to practice it, right? When you're at home, when you're out in social situations, when you're with your kids, when you're with your spouse, that's the best time to practice listening. And just without making them feel like you're practicing for something you think is more important.
Right. That's key. So you guys handle a fair share of catastrophic injury and wrongful death cases where, potentially millions are on the line. What is the non-negotiable strategic moves you make to position a case like that for a strong outcome? For
a catastrophic case, wrongful death catastrophic case, one thing that you always like to have as a non-negotiable is I like to have my experts lined up before I have a complaint drafted. Because, on the plaintiff side of the bar, you've got the benefit of time, right? And as soon as you file that lawsuit, you're now on an equal playing field and sometimes a lesser playing field than the defendants. And you've got deadlines to keep up with and all that sort of thing. And plus you're getting things from them that you're having to respond to. So on the big cases, the complicated cases, I like to make sure I've got expert reports ready to go before I even file a lawsuit, at a minimum before I file my initial disclosure statement. In Arizona, it's like a lot of other states, you don't have to send expert reports until after your initial disclosure. My experience is that when I send with an initial disclosure, an expert report, deposition notices, and some requests for admission or any sort of interrogatory, not only am I better prepared, am I a better lawyer, right? Because I've taken that benefit of time that I had before I filed suit to think everything through and play it out like you want to play it out. But you're also sending a message to the other side that, hey, we're ready to go. We could ask the court for a trial date as soon as you answer these questions. And now they're very much on the defensive. You can't do it in every single case, right? Sometimes because it's cost prohibitive. Sometimes it's because if you've got 100 cases on your docket, how are you going to do that before filing suit on any of them? But you pick your spots. And like I said, it's to the point of non-negotiable. I've told clients, look, I understand you're in a hurry to file a lawsuit like yesterday. If you want to file a lawsuit tomorrow, there's a lawyer here in town who will do that for you, but I'm not him. I want to do it more thoughtfully.
Yeah. Being prepared, having the right strategy
changes everything.
Yeah. And fundamentally in business and in the courtroom, wherever, right? That's certainly an important foundational.
And we're too busy to be reactive, right? I mean, you fall into the habit of being reactive because you're busy. But, if you're a big firm and you've got hundreds and hundreds of cases and multiple paralegals that you're working with, or if you're a small firm, which usually means you're not only doing your caseload, but you're also doing firm management type of stuff, it's easy to fall into the habit of being reactive, but it's not going to work. And so you've got to do everything up front as much as you possibly can. So that, because I've always thought, and this is getting on a little bit of a tangent, but I've always thought that the hardest part about the plaintiff's practice is that it's your job to keep the ball moving, right? The insurance company is never going to call you and say, hey, I've got this check I would like to send you. Will you please do X, Y, and Z? They'll let it sit for years if you let them. And so many jobs, really short of being like a CEO, right, or some C-suite person, you're doing things because you've been asked to do them or told to do them, and it's part of your role, and it's reactive. It's really, one of the few jobs in the world where you can go to work every day and not do anything, right? And nobody's going to know until months in when nothing has happened. And I've found it, so many people I've talked to about it. I've experienced it myself when I was a baby lawyer. When you really notice it when you bring defense lawyers in, who are now plaintiffs lawyers, that, we have a joke in the office that if one of the lawyers walks into another one's office and you're just kind of sitting there staring at nothing, we call that lawyering, because that's what you're just sitting there thinking. And I have meetings once a week by myself, and then also with my staff, where I go through every single case. And the question is, okay, what do we do to push the ball forward next? Because it's easy to become reactive, and then you're not doing that stuff. And it's the hardest, to me at least, it's the hardest part of the job.
Yeah. Well, and insurance companies will happily sit on their money for as long as they possibly can. So yeah, you're right.
That's exactly right. Just let those reserves make money.
Yeah. Yeah. Well, unfortunately, I learned that in my own case, seeing how hard they fought on a pretty clear liability case, and pushed it until they finally wrote a check. But that's the reality.
The bigger the case, the harder they're going to push, right? The exact same set of facts. And if they've got 300,000 in limits versus if they have $1 million in limits, it's a completely different defense, because they care more all of a sudden.
Yeah. Yeah, it was interesting, in my case, because I got to say to the adjuster, I said, do you really want to put a lawyer on the stand to describe what, 21 days in the hospital were like, 10 days in the ICU, not being able to eat normally for about a year and a half, and my jaw wired shut for 3 months? Do you really want me to explain that in great detail to the jury and see what happens, or do you want to pay?
Right. And they don't want to hear it, but they want to wait until the very last second.
Yeah.
Not much goes to trial anymore as compared to back in the day. And, you talk to a lot of lawyers who say that they almost refer themselves as arbitration lawyers as opposed to trial lawyers, because so much stuff goes to ADR and gets resolved earlier than trial. But we joke in our office that you get so good at like final trial management statements because we do those time and time and time again. And it a lot of times feels like the adjuster hasn't been paying any attention until they read that final trial management statement. And then all of a sudden they find an extra zero under the couch. And it makes all the difference in the world. But that goes back to they're being reactionary, right?
Well, and carrying a million cases that they're managing too. I mean, having seen it on the defense side, that was what would frustrate the heck out of me is, I write this lengthy explanation of why this case should be settled, and the adjuster didn't bother reading it until they're sitting there in the mediation and go, oh, I don't have sufficient authority to settle this because I didn't read this and prep and go up the chain to get the right,
Arizona mandates mediation in all of our cases. And I think it's a real disservice. I understand why they try to do it, but the number of cases that don't settle mediation because one side or the other is just checking a box. And I've had more cases where the defendant shows up and I get a call from the defense lawyer that morning. It's like, hey, just so you know, this isn't going to settle today. They just told me they're only coming with X in authority. I told them a month and a half ago they need to come with Y in authority. And so it's just not going to settle because they see it as just, we have to do it anyway. And I co-counsel with lawyers from all over the country all the time. And it's one of the benefits of living in Arizona. Everybody knows somebody who comes for spring training or has a winter house or, golfs out here or whatever it might be. And the states that don't really mandate it, their lawyers will suggest to me, when the defendants bring up mediation, we'll tell them we'll mediate it if they agree that they're going to show up with X authority or the starting offer is this. And I say, well, we don't have that tool in our toolbox here because we've got to show up whether they do it or not. And I think that would be a really effective tool for a defense lawyer to say to an insurance adjuster, hey, you need to pay attention now because I know you want to mediate this, but we have to at least make this offer before we get there. And it would I think that would get the process moving faster.
I know that you've been involved in some of the thought leadership around sports concussions and dealt with product liability. Those types of cases are pretty brutal on experts and evidence. And I'm curious about what your strategies are when the defense is betting the jury won't understand science.
I mean, strategies are ever evolving. At its baseline, though, is it's being creative and up to date on how to make it simple, right? And generally, if I can understand it, I'm confident that a jury can understand it. And just keeping it as simple and as quick as possible, not keeping the expert on for an hour when you can have the expert on for 5 minutes. Let the defendant try to make it super complicated and then explain to the jury why they're trying to make it complicated, because it's really simple. But their problem is if you understand that it's simple, we win. And so they're trying to muddy the waters. We use focus groups all the time for that exact sort of thing. I'm now using AI for that exact sort of thing. And honestly, just frank conversations with your experts, sending a report back and saying, I don't understand what it says. I know what my case is and I don't know if this helps me or not. Can you tell me, does this help me? And we need to start over on that. But you're right. It's a real difficult thing. And sometimes it's just, sort of explaining to the jury, I don't have to explain to you the mechanics of how, we had a case where the experts were metallurgists and every piece of evidence was microscopic. It was a bottle cap that flew off a bottle and blinded our client in one eye. And it came down to how it was made and that the machine didn't press it hard enough. And it was sort of a blessing that we couldn't tell what it was about the machine that went wrong. We just knew it didn't work. So we didn't have to get into that. And then dumbing it down, one of the defenses was, the defense expert found titanium on the bottle cap and said, well, she was clearly hitting it with a fork. And so we asked our expert about that. And he explained to us why that didn't make any sense, but it was really scientific. And I told him I didn't understand anything he just said. And he said, let me dumb it down for you. Go look how much it would cost if all of your silverware was made out of titanium. And I was like, see, that I can go to a jury with, right? That I can take to a jury and say, who in their house has a $200 set of forks? Nobody. And so, but your point is well taken. It's extremely difficult to do, and you have to, be it through focus groups or anything else, put a lot of time and effort. And we had a lawyer, he's passed away at this point, but he was ER doc, and he only did med mal, and he was brilliant, but he couldn't talk to a normal person. And so our deal with him was he would help us with understanding the science on our med mal cases. If he was allowed to come in and explain his med mal cases, and we would explain to him how to say this to a normal person. It's never changing, and you have to stay on your toes about how you make things simple.
Well, I feel dumb because is there such a thing as titanium silverware? I thought it was just all metal. Maybe I'm missing something. You really need lightweight forks.
And I'm saying titanium, and now it might have been graphite, because whatever it was we were talking about, whichever one it was, we were talking about shafts of golf clubs, that's where you see it. And what is interesting, one of the cool parts of the job, right, is you learn about all different areas of the world and get to become a little expert on something for, a brief amount of time. Apparently, it's a very good holder of color, and it's frequently used in makeup. And so our expert said, call your client and find out what mascara she was wearing that day. And I bet if you look up the ingredients, and I'll be damned if I didn't look up the ingredients in the mascara she had on and the metal was in there because it's a good holder of color.
Oh, wow. That's crazy.
Yeah, weird stuff that you learn, right?
Yeah. So I wanted to ask you a bit about law firm operations and efficiency, because you practice in a big national firm and now you're in a plaintiff side boutique small firm. I'm curious if there were any operational lessons that carried over from the practice you're a part of and that you incorporated into your practice.
I think the biggest thing is systems. I mean, big firms implement systems and processes almost as like a quality control. And so everybody knows their role. And in a small firm, it feels unnecessary. You get into a habit of not doing it. Everybody's sort of, your team does things how they work for you, and the team next to you might not do it the same way because they've come up with a different thing, or just because you didn't have a conversation about how to do it as a firm. We're actually in the middle of this right now of trying to be thoughtful about putting systems into place to make everybody's jobs easier. And we're having a firm lunch later this week going through how we're ordering medical records, because ordering medical records is a nightmare and it takes forever and it's getting worse, not better. And you can hire a company to do it, and we have not had success with those companies for any number of reasons. And so as opposed to just telling the person who's now going to be in charge of doing that, work with, each paralegal individually and figure it out. Having, okay, this is how the system works that we do it, and let's put it together as a firm so it works for everybody, which that's a benefit of being in a small boutique firm, right? It's easy for me to get 6 paralegals in a room and have a conversation as opposed to a huge firm with 100 paralegals. And let's find a way that works for everybody so that this person knows what their job is, you know what your job is, and it works a lot more smoothly. And you don't have to spend as much time thinking about that stuff, and you can focus on your cases.
It's interesting that you talked about medical records, because I wrote something recently just about, the fear of implementing technology and how do we use that effectively to limit time spent on what is administrative tasks. Because, medical records is similar to lien resolution, what we do, where there are certain instances where it's inefficient for the law firm to handle that on their own, but having a broad process in place, for example, to handle medical records, and then allowing, the right partner, if you find that right partner in that space, or a partner like us in the lien resolution space, that then helps support those processes and make the firm run more efficiently.
And you really have to be thoughtful about it on a process by process basis, right? So we work with you guys and it's been wonderful, and Synergy is now an integral part of our team. I would consider it, right? We've tried it with medical records, and without getting into the weeds of the differences between medical records and liens, our experience is you still have to, I hate to use the word babysit, but that's kind of what it is, each single records request. And because, Synergy does a good job of, when a lien holder says, well, this is the best we can do, we usually get an email that says, but let me keep trying. I think I can do better, right? In the medical record space, you also often get an email that just says, hey, this is what they're charging you. Plus you need to pay us for what we're doing. And so really what has been saved. And it's a tricky one with AI, because if it was just sending out form letters, AI could do that pretty easily. But when it's following up and saying, no, you're charging us too much, under high tech and this and that and the other thing, there's just a lot to it. There's really no good way. I would say that we've found about it, but with the amount of activity on different email threads that I see about, has anybody found a good answer to this problem? It's not just us. which makes me feel a little bit better.
Yeah. I mean, I do think with what's happening technology-wise, because I've seen some players that are trying to come up with different solutions to that problem. I think eventually there'll be better solutions in that space because it's being tackled by some of the players that want to be kind of the technology backbone for analyzing that information and helping then formulate the demands and organize all of the information so that you can query it using AI. So I do think there's probably going to be some changes to that, but we're definitely at a I think we're getting to a tipping point to where we're going to see some advances in all of these areas because things are moving so fast right now, just by virtue of that.
I think that's absolutely correct. And you try out new things. And that's kind of the scary thing about AI and where technology is right now, right? You just see a shiny new toy and you want to jump all in. And being, patient with it and really meticulous about the choices you make and things like that.
Yeah, there's definitely a process, just like you were talking about, that really you need to look at, well, where in your practice would it create efficiency versus just be more of a time suck learning another platform or another technology. But it's going to get to a point where once everybody's thrown their hat in the ring, you see the clear winners of what technology will work in reality, in the real world, while you're trying to move cases forward more quickly.
Well, it's interesting what you said, it's going to be tackled by the people that kind of are wanting to be out in front of all of this. I think, in my opinion, one of the issues that, at least on the plaintiff's business side, right? So plaintiffs firms all over the country who are getting called by the same vendors, same third-party partners, things like that, is you've got a lot of companies that want to be great at everything. They want to take over the whole world, right? They want to do case management. They also want to do AI. They want to do whatever the other thing is, so that part of their pitch to you can be, hey, you can get rid of X, Y, and Z and just hire us. But as a result of that, right, you're going to sacrifice on the quality of all of it, is what I've found. I have found, that case management solutions, be a great case management solution. You don't also have to put all this time and money into also, being the best AI solution or the best medical records retrieval solution or the best lien resolve solution. Like, let the lien people do liens, let the medical record people do medical. But these decisions aren't being driven by lawyers, right? Or plaintiffs' lawyers, at least. They're being driven by the investment funds that are pumping money into these people and wanting returns.
Yeah, the amount of money that's pouring into legal tech, because I've seen it, because I follow it just as a student of the industry, it's pretty mind-blowing and it's the bigger players, which it makes sense. They're trying to consolidate everything together, like you said, and be everything to everybody. Some of that may succeed. Some of it may embed technology that it does work well and it makes sense. And some of it's just too specialized for it to be part of these broader solutions. But that's what I'm saying. All that's going to shake out, probably in the next year or two, because I think it's going to probably move that fast.
Well, and what'll be interesting to me is it being a small boutique litigation focused firm. A lot of these solutions are difficult for us to bring on because they're cost prohibitive, right? Because you don't bring in, we don't bring in enough cases. Some of these some of these vendors that, you need to bring in 200, 300, 500 cases a month to justify the expense. And most small litigation oriented firms, if they're doing a good job on their cases, aren't bringing in that many cases. But the counterbalance to that, right, is that the litigation business model isn't really well understood by a lot of just Harvard business grads, that they've learned how business is supposed to look. And the profit model doesn't match up with people investing round A, B, and C of funds and with shareholders and stuff like that. Now, what does work for that business model is pre-lit, if you just want a pre-lit firm that commoditizes injured people. And so a lot of these services you see built that would really work or really do work well for pre-lit. But when you get into the litigation sphere, struggle. And what's interesting is when I talk to a lot of these people that are like the C-suite folks in these companies, they love the idea of getting into litigation, making themselves more flexible, being more helpful to the firms that are doing the big cases that are more interesting, have more concepts behind them, more ways that they can be helpful on the litigation side. But they've got this other force over there saying, litigation's way too like this from a profit and loss standpoint. We want something that's very much like this and it's predictable.
Well, time will tell, ultimately. So I wanted to ask you a bit about leadership, because you serve on AJ's Board of Governors and you're involved in efforts on education in Arizona for trial lawyers. How has that leadership work shaped the way you run your own cases and mentor others?
I think it's twofold. But the first thing that comes to mind for me is that so many plaintiffs' firms are smaller firms, right? You've got the big monster firms, but so many plaintiffs' firms are smaller firms. And coming from a big firm background, that really jumps out to me. And as a result, I've just found a community, both on the Arizona level and on the national level, of plaintiff lawyer firms that want to operate like a firm. We want to share information. We want to share education. We want to help each other get better. On the AAJ front, you want to pass laws that help all your clients. There's a number of times we have conversations where something comes up that doesn't really impact my clients, but then an employment lawyer on the plaintiff side says, well, no, this is a bad thing because of this. And then we all kind of get behind it because at its core, we're all helping individuals who are fighting against big corporations, be it insurance companies or corporations who are actually at fault themselves. And so, the leadership part of it and this education part of it in Arizona really comes from that. It's all boats need to be rowing in the same direction, the stay in the ocean theme from Arizona, right? What a rising tide is good for all the ships. And so that's been, you talk about mentoring. When I talk to young lawyers or even older lawyers who just aren't involved yet, I always tell them, I think the first thing everybody needs to do is join AAJ. To be a plaintiff's trial lawyer, you need to be a member of AAJ. You need to be a member of your state board. Or not even on the board, but part of your state association, just to get that process started. It opens you up to the CLEs. It opens you up to the community. The wealth of information where if you're in a big firm, you've got a motion you've never had to respond to before on a legal issue you haven't dealt with. You can send an email to a whole firm or walk down the hallway and get an answer. We don't have that in our smaller firms, right? But through the community that has been built both on a national and local level, you have that if people are willing to put into it. And so that's how I grew up in this, right? My dad's been doing this work for 40 plus years. Has people ask me how long have you been on the AAJ board? How long when did you start going to conventions? I'm a first year lawyer. When should I start going? When did you start? I'm like, well, I started when I was 4. My daughter started when she was 2. It's sort of in our blood. I'm what they call an outlet brat because I've been doing it for so long. But so it's in my blood for that reason. But I think it's extremely important you become a better lawyer when you do that sort of stuff.
Yeah, it's one of the beauties of this profession. Having been a part of many of the trial lawyer listservs over the years, including, the AAJ, and seeing how other lawyers help other lawyers, it's something you don't typically see, and you certainly don't see it on the defense side like what you see in the plaintiff's bar, and what separates this group out who's fighting for each and every one of us when, something like what happened to me happens, and you need someone who can go fight that fight for you.
By nature, plaintiffs' lawyers are by and large, right? All rules have exceptions, but by and large, plaintiffs' lawyers are empathetic people, and they spend their days helping other people. And, there's that bumper sticker that says before you honk, realize that everybody's fighting a battle you don't know about. And in the plaintiff's law firm, we see that every single day, right? The dumbest thing I do every day is I ask my client, how are you? They're like, well, if I was good, I wouldn't be talking to you, man. And so I think that carries over from our clients into how we see the rest of the world, how we look at, each other, how we want to help each other, how we want to bring up good lawyers, the future generations of lawyers. We're lucky that what we do for a living it's engraved in the Constitution. To the extent that the Constitution still exists, it's still there. And not many lawyers could say, well, I'm fighting for the Seventh Amendment every single day. And the other part of it that, I've thought about a lot, is most people, you'll understand this, right? You come out of law school and you're going to argue at the Supreme Court at some point in your career, right? You're going to have that $500 million verdict, or they're going to make a movie like Erin Brockovich about you, right? Not everybody can do that. Not because they're not talented enough, but just because that case doesn't walk through the doors, right? If I had $1 for every time I had $1 million injury and $100,000 policy limits, I think as I get older and have kids and stuff like that, about what's your legacy, right? And maybe your legacy gets to be that case. Maybe that case, as soon as you and I hang up, maybe that case walks in my door. Maybe that case never walks in my door. But if it doesn't, I'd still like to have a legacy. And the leadership stuff through AAJ and what we're doing in AAJ and on the local level, the Arizona trial lawyers, the bad bills we fight off, the good bills we pass, that's a real opportunity to be a part of something that leaves a legacy that keeps the courtroom doors open for people 10, 20, 30, 50 years from now. When keeping those courtroom doors open is more important now than it's ever been before.
Yeah. But you brought up something that I, as a foundation, deliberately built into our culture, was this idea of empathy and try to create the understanding of the importance of the work that we do, the opportunity and privilege that we get to be part of the ecosystem that is helping people when they've been significantly injured. So I really connect with that and believe in it very strongly. Also, having been part of that and experienced it from, laying in a hospital bed and being visited by my personal injury lawyer to, going through the entirety of that process, all of that is, it really is a cool thing for me to see a company that we've built serve in that way, because you don't get that opportunity in a lot of professions or areas.
It's one of the most special things you get to do, right? To stand next to somebody at their most difficult, God willing, their most difficult point of their life. Where we see it all the time, or I shouldn't say see it all the time, but it gets brought to our attention all the time, is with head injury clients, right? They are, bar none, the most difficult batch of clients you can ever have. They're frustrating. You have to tell them things 5, 10, 15 times. And when you represent them for a couple years and they become like friends and family to you, it's easy to be stuck in the moment and want to strangle them. Be like, why is this so difficult? And then we just have to remind each other, like, hey, what are their injuries? Oh, they had a TB. That's why they're difficult. Okay. And you take a step back and realize that, and that happens all the time, but it's a skill that a lot of people don't have in the world, to really put themselves in somebody else's shoes. And to be a good plaintiff's lawyer, you have to do it. You don't have a choice, right? If you can't put yourself in your client's shoes, then you have no business doing this job, and you're forced to learn to do it come hell or high water. But it serves you well in so many other aspects of your life.
Yeah, definitely. From your vantage point, from both trying cases and being involved with AAJ and bar associations and whatnot, What do you see as the real existential threat trial lawyers are going to face in the next 3 to 5 years?
I mean, everybody always wants to put us out of business. Like that's that's a constant existential threat. But I don't see that changing. I think that what you see, not to get political about it, but what you see on the national level, right, taking rights away from people on an individual basis, they're coming for us at some point. They've come for us in the past with tort reform, right? And they'll come for us again, and they're just going to keep knocking. We have more and more judges that have never been in a courtroom until they've got a robe on. You've got public perception of what we do for a living it was real bad back in the Bush days. It's gotten better. But now, the powers in the world today are not the types of people that like lawsuits because they don't like their companies getting sued. And so, it seems to me that because I do so much legislative stuff at the Arizona and national level through AHA, there's always the big shiny thing that everybody's talking about, whatever that bill of the cycle is or whatever it might be. But there's always one that nobody's talking about that has an immunity, right? Or that has a rule that makes it more difficult for us to get, what our clients deserve. And I'm always shocked. Arizona's lucky. We've got in our state constitution that you can't have caps on damages.
It's lucky.
Yeah. And it's really become noticeable to me of late. I feel like more and more people call me and from all over the country lead with what are Arizona's caps on, name this kind of case. Because it seems like every year there's another state that's got caps on damages. I mean, Florida, what was it? The year 18 months ago just had their tort system upended, right? I get calls from people in New Mexico and Texas who say, hey, their caps are on the ballot this year. I know Arizona's avoided it. What were your strategies? And I said, well, when Dodge Phelps was the only company in the state, the legislators put it in the Constitution. But so I see caps on damages as being a constant existential knocking on the door. And any form of tort reform that you can think of, they've already thought of it up to and including how do we just get rid of the 7th Amendment? And I think it's that serious. I think that is, I do think that that's on their list. It has to be because the only thing that matters to the people who don't like what we do for a living is money. Nothing else is important to them. And so how are they going to protect their money, right? And they're going to make it impossible for us to do what we want to do.
Yeah, it's kind of scary with what's going on. Sean Dominic was on the podcast not too long ago, and we were talking a bit about that and his involvement, being a past president of AHA with some of the litigation, trying to, curb the assault on the rule of law that's happening right now. And watching it is really disheartening to see some of the things that are going on, how many people are willing to accept it as this is okay. And it makes me fearful for what's to come, but
it's terrifying. I mean, and when I have friends who, again, not to make it political, but when I have friends who are otherwise in favor of most everything that's going on right now, right? But they look at me and they say, I feel like the only thing that stands between us and the end of the United States as we know it is lawyers and the ability to go to court. Because the only time I feel like I see good news is when a court has said, no, slow down. That really, these are people that don't otherwise know anything about this field of play and are, politically conservative in that they would generally not be, not necessarily they would be in favor of everything that's going on right now, but that's the way they lean. And they're like, yeah, but this whole, the president shouldn't be able to punish judges and lawyers for who they represent and judges for how they rule and stuff like that. It's real. And, you bring up AHA presidents. I'm fortunate enough to be friends with all the recent ones, right, in my time. And that's a huge, for a lot of them, you can't try cases while you're president, or if you do, it's very, very difficult to have the time to do it. You've got to have a big staff and some other lawyers in your firm who are supportive and things like that. But we're lucky enough that most all of them look at it as like, this is the most important case I'm ever going to have to try, because this is the case that allows all the other cases to be tried. And so if that means I got to take a year, 2 years to litigate less and do more of that, then somebody's got to do it, right? I mean, and so we're fortunate that all of our presidents of late have had that mentality.
That's a huge commitment. Well, so you've been generous with your time. Last question I always ask it, very open-ended, so you can answer it however you want. So as a litigator, as a leader, with your experience, what's your view as a trial lawyer?
Well, my view in the moment is that I haven't figured out what I'm making my daughter for dinner tonight. So that's view one. I'm realizing we've passed the lunch hour and I haven't even started thinking about what's for dinner tonight. But, my view as a trial lawyer right now is that, and I'm sure every lawyer ever has said this, that what we're doing has never been more important. And it's important to fight the tough cases. We've talked a little bit about, and everybody's talking all the time about how helpful AI and technology is, right? But that technology is not going to be all good. It already hasn't been all good. And that technology has already hurt people and is going to continue to hurt people. And those cases are going to be tougher cases. We're not all that far from a world where every car crash case is a products case. And that might make sense in a catastrophic car crash case to try a products case. But in a car crash case that isn't catastrophic, the question, it's from the business perspective, you've had the conversation, right? Of do the damages justify this case? And that is something that keeps me up at night, is not, how's the business going to survive? Are my kids going to be able to eat? Or am I going to be able to provide for my family because this is going to go away? I'm lucky we're in a firm that we do a whole bunch of different types of cases. We do high-end cases. And so, if everything became a perfectly drivable car, my business wouldn't go away. But the perspective of you're going to have people out there who are getting negatively impacted by these fast advancements in technology with fewer and fewer recourses, because it's going to be, in the car crash sense, really difficult to try a products case on herniated discs, right? And so I spend a ton of time thinking about that, and a ton of time thinking about how to, big cases and small cases, how to push those all the way through to keep getting lawyers, especially young lawyers, trial experience, right? My generation has less trial experience than the generation before us, and everything suggests the generation after me is going to have less trial experience than us. And having firms that are willing to litigate, we didn't even talk about, we could do a whole nother hour on the alternative business structure that Arizona has. And the model of the billboard, where you're just bringing in thousands of cases and just churning them. And it's just churn and churn and churn. And what that does to the practice on the greater level, how there are cases out there that's there to serve, and that's a good thing. And there's cases out there that's not the firm for them. Just like my firm, there's cases that my firm's not the firm for you, and they are. But with this alternative business model, their plans are basically, from so far as I can tell, let's get in all the cases, and then we can just ship them out, take referral fees on everything, and completely squeeze the people that actually are willing to go to trial. So it's a fascinating time to be doing what we're doing. Fascinating sounds a lot like frightening, and I'm not always sure that it's all that different. But it's, like you said, it's going to move fast. I don't think these are questions that we're going to need to wait a decade to have answers to, for better or for worse. But we're going to keep fighting until then.
Yeah, the ABS is a whole interesting topic, especially with private equity pouring in, and like what you've seen in the mass tort space, and it is going to play out quickly. I think you're right. So we will see how that plays out. Well, so for anyone that's listening to the podcast that has a case, in Arizona needs to co-counsel or wants to refer a case out, can you talk a little bit about your firm and then how the best way to get in touch with you?
Sure. So we're located in Phoenix. We try cases all over Arizona. We've been around for 40 years. My dad, Frank, and his partner, Richard, started it in 91. Like I said, we're located in Phoenix, but we can try cases all over the place. Our website is www.pvazlaw.com. My email is first initial last name at pvazlaw.com. So N Verderame at pvazlaw.com. You can chat with us on our website. You can call us. There's no shortage of ways to get a hold of us. I've been told we have Instagram and Facebook and all that stuff too, but I'm not as involved in that end of it.
Well, we'll link to all that stuff too as part of the episode notes. Nick, thanks for your time today, and we'll see everybody on the next episode of Trial Lawyer View.
Thanks for having me.
Here is another episode of Trial Lawyer View. We hope you enjoyed today's guest and discussion. Tune in to our next episode for more helpful insights from fellow trial lawyers and practice experts. This podcast is brought to you by Synergy. Visit partnerwithsynergy.com to learn more about how Synergy can free your firm to focus on what it does best.